India Legal presents Court This Week.
Hello and welcome to Courts This Week. I'm Heshe. In this special edition, we bring you top stories of legal proceedings from the courts, from lower to subordinate courts to higher courts and the Supreme Court. We bring you a selection of major legal proceedings which made headlines this week. In the next half an hour, we will inform and update you on all important proceedings. So let's begin Courts This Week.
India Legal presents Court This Week.
The Supreme Court has orally expressed unhappiness over the fact that the recommendation made by the Tamil Nadu state government for the remission of the sentence of AG Perarivalan, the convict in Rajiv Gandhi assassination case, had been pending before the governor for over 2 years. Justice L. Nageshwar Rao, the presiding judge of the bench, observed, "We do not want to exercise a jurisdiction, but we are not happy with how this recommendation has been pending before the governor for 2 years." The Supreme Court has observed that it was not happy with how the recommendation of Tamil Nadu government for remission of the sentence of AG Perarivalan, convict in the Rajiv Gandhi assassination case, has been pending with the governor for over 2 years. The bench of Justices L. Nageshwar Rao, Ajay Rastogi and Hemant Gupta asked Additional Advocate General for Tamil Nadu, Balaji Srinivasan, to find out why the governor has not decided on the recommendation of the state government. Srinivasan informed the court that the matter before Governor Banwari Lal Purohit was that of a larger conspiracy and that he was awaiting a report from the CBI. In response to this, the court said, "We don't want to exercise jurisdiction, but we are not happy with how the recommendation has been pending before the governor for 2 years. Appearing for the petitioner's senior advocate, Gopal Shankar Narayan contended that in the Nelofer Nisha case, related to the same remission notification, the court exercised its power under Article 142 of the Constitution to release the prisoners. Shankar Narayan further stated that grant of remission was the prerogative of the governor and is not under the Code of Criminal Procedure. The court has now asked the council to submit cases and points of law to show how the Supreme Court can give direction to the governor. Justice Rao referred to the 2014 judgment in the Shatrughan Chauhan case, wherein the Supreme Court held that mercy petitions have to be decided in a time-bound manner. He also cited a case where the governor had been asked to take decision concerning the assembly. Additional Solicitor General of India, K.N. Nataraj, told the court that the investigation on the angle of a larger conspiracy was spread over the United Kingdom and Sri Lanka, and that the Central Bureau of Investigation was waiting for replies to its latest rogatory. Justice Rao then asked, "Larger conspiracy probe is pending for 20 years and going. Still, you are at the stage of getting replies of rogatory letters from the UK, etc." Perarivalan was awarded the death penalty in 1991 for his involvement in the conspiracy to assassinate then Prime Minister Rajiv Gandhi. He was charged for providing a 9-volt battery to co-conspirator Shivrasan for the explosive device used to kill Gandhi. After he spent 20 years on death row, the Supreme Court commuted Perarivalan death penalty to life imprisonment in February 2014. In September 2018, the government of Tamil Nadu announced its decision to release him along with 6 other convicts. And the Supreme Court has stayed the Election Commission of India's order revoking senior Madhya Pradesh Congress leader Kamal Nath's star campaigner status in the upcoming by-polls in the state. A three-judge bench headed by Chief Justice of India S.A. Bobde questioned the poll body over its decision. The bench asked, where does EC have the power to determine who will be the leader of a party under Section 77 of Representation of People's Act? The Supreme Court has stayed the 30th of October order of the Election Commission of India delisting former Madhya Pradesh Chief Minister Kamal Nath as the star campaigner for the upcoming by-election in the state. The bench of Chief Justice of India S.A. Bobde, A.S. Bhopana and V. Ramasubramanian pulled up the ECI for exceeding its power by passing the order. Senior advocate Rakesh Dwivedi, appearing for this ECI, submitted that the matter is infructuous now, as the campaign is over and the polls are slated to be held tomorrow. However, CJI said, we are staying your order. Who has given the power to you? Delist a candidate from being a star campaigner or a leader of the party under Section 77 of the Act? We have read it. When Dwivedi urged the court to not stay the order and instead call for a reply from the ECI, the bench refused to agree. It stated that the ECI will have to reply and that the order will be stayed pending further orders. Senior advocate Kapil Sibal, appearing for Kamal Nath, submitted that ECI order was passed arbitrarily as no notice was issued to Nath for it. In this order, the ECI has stated that Nath's star campaigner status was being revoked for repeated violation of Model Code of Conduct and for complete disregard of warnings issued to him. According to ECI, Nath, being a leader of a political party, had repeatedly breached ethical and dignified behavior. Kamal Nath had earlier been warned by the Election Commission after he used the word item for a woman Bharatiya Janata Party candidate who is a former Congress leader and among the 22 MLAs whose exit led to collapse of his government in March. Campaigning in Dabra, he had mocked BJP's Imarti Devi, saying that the Congress candidate was a simple person unlike his rival who was an item. In his plea, Nath states that the ECI had already passed an order on October 26th on the same complaint by the BJP and had advised the Congress leader to not use such words. However, pushing him again through the October 30th order is completely in teeth of principles of fair play and res judicate, he claimed. The plea filed by advocate on record KVC law officers and drafted by advocate Varun K. Chopra and Gurtejpal Singh states that the 30th October order of the poll body is illegal, arbitrary and unreasoned. The petition goes on to allege that leaders of the BJP have been repeatedly making statements ex face in violation of Model Code of Conduct during the period of campaigning for the by-election. However, no such action has been taken against such person by the ECI, says Kamal Nath in his plea. Kamal Nath has further claimed that the Election Commission did not issue any notice to him before passing the order to take away his star campaigner status. Bureau Report. And in a major verdict, the Supreme Court has set a benchmark for maintenance to be paid by a husband to his estranged wife. The apex court judgment dealt with criteria for payment of interim maintenance and the issue of overlapping jurisdiction of different courts.
The Supreme Court has laid down guidelines for determining the quantum of interim compensation to be paid in matrimonial cases. A bench of Justices Indu Malhotra and R. Subhash Reddy also laid down directions to be followed by family courts, district courts and magistrate courts across the country to address the issue of overlapping jurisdiction and to avoid conflicting orders being passed in different proceedings in the same matter. The judgment was pronounced in a matrimonial case from Maharashtra in which the question of maintenance of a wife and son under Section 125 of the Code of Criminal Procedure had come to the fore. The court had on September 1 last year appointed senior advocates Gopal, Sankar Narayanan and Anita Chennai as amicus curiae to assist in framing guidelines on payment of interim maintenance. The judgment dealt with the following aspects. Payment of interim maintenance. The court ruled that an affidavit of disclosure of assets and liabilities annexed to the judgment should be filed by both parties in all maintenance proceedings, including pending proceedings before the concerned family courts, district courts or magistrate courts throughout the country. Criteria for determining quantum of maintenance. For determining the quantum of maintenance payable to an applicant, the concerned court shall consider the criteria enumerated in the judgment. The court made it clear that the said factors laid down by it are not exhaustive and that judicial discretion is vested in the family courts to consider any other factor which may arise in the facts and circumstances of the case. Overlapping jurisdiction. The court said that it has become necessary to issue directions to overcome the issue of overlapping jurisdiction and to avoid conflicting orders being passed in different proceedings. Such directions are necessary so that there is uniformity in the practices followed by family courts, district courts and magistrate courts throughout the country. The following direction were issued by the courts toward that end. Where successive claims for maintenance are made under different statutes, the court would consider adjustment or set-off of the amount awarded in a previous proceedings while determining whether any further amount is to be awarded in the subsequent proceedings. It is mandatory for the applicant to disclose during the subsequent proceedings details of the previous proceedings and the orders passed in such previous proceedings. If the order passed in the previous proceedings require any modification or variation, the party would be required to move the concerned court in the same proceeding. The court ruled that an order of maintenance may be enforced, executed under Section 28A of the Hindu Marriage Act, Section 26 of the Domestic Violence Act or Section 128 of Criminal Procedure Code. Further, an order for maintenance may be enforced as money decree under the Code of Civil Procedure. Bureau Report.
In the Yes Bank money laundering case, Bombay High Court has rejected bail pleas of DHLF promoters Dheeraj and Kapil Vardhavan. In CBI case, the Vardhavan brothers are accused of diverting nearly 4,122 crore rupees from the General Provident Fund and Central Provident Fund deposits of a UP Power Corporation Limited to their company. They have also been accused of fraudulently diverting nearly 12,700 crore rupees from DHLF's accounts to companies beneficially owned by them and further diverting those funds to the other firms.
The Bombay High Court has rejected bail pleas of former DHLF promoters Kapil and Dheeraj Vadhavan, accused in Yes Bank money laundering case. A senior judge bench of Justice Sarang V. Kotwal passed orders on pleas made by Vadhavan brothers. On March 7, the CBI had registered a case against Kapil and Dheeraj Vadhavan along with Rana Kapoor, the then Managing Director and Chief Executive Officer of Yes Bank, and others in connection with an alleged multi-crore scam connected to Yes Bank. The CBI took custody of Vadhavan brothers from Satara, Maharashtra in April this year. The CBI claimed that both Kapil and Dheeraj were on the run since the beginning of the investigation. On March 9, the CBI raided the premises of the accused, but their whereabouts remained unknown. The CBI had then issued them a notice which went ignored. The same month, a non-bailable arrest warrant was issued. The Enforcement Directorate is also investigating allegations of money laundering in the Yes Bank case. Representing Kapil Vadhavan, senior advocate Amit Desai had submitted before the High Court that CBI had not complied with the procedure under Section 173 of Criminal Procedure Code, which lays down procedure for reports of police officers on completion of investigation, while submitting the investigation report to the special magistrate. He argued that if the report is not complete, the court could not take cognizance and consequently the provisions could not be considered. Senior counsel Abhishek Manu Singhvi, appearing for Dheeraj Vadhavan, has submitted that statutory bail was a vital liberty and an indefeasible right. Singhvi said that the charge sheet filed did not provide sufficient evidence to prove all alleged offences. Additional Solicitor General Anil Singh, representing CBI, opposed the pleas, stating that all procedures and compliances were followed as per law by the CBI officials. Earlier on August 20, observing that undue delay is not conducive to administration of criminal justice, a single judge bench of Justice Bharti H. Dangle of High Court had granted bail by default to DHLF promoter Dheeraj and Kapil Badwan, accused in Yes Bank money laundering case, as Enforcement Directorate could not file a prosecution complaint or charge sheet within stipulated 60 days of their arrest. Bureau Report.
And a three-judge bench of the Supreme Court headed by Justice Ashok Bhushan issued notice to Telugu Desam Party leader Varla Ramaiah on an appeal by Andhra Pradesh government against Andhra Pradesh High Court ordering stalling probe into Amravati land scam. The Supreme Court has issued notice on the appeal by Andhra Pradesh government challenging stay granted by Andhra Pradesh High Court of the SIT probe into alleged irregularities into projects started by the previous TDP government, including land acquisition in Amravati. A bench of Justices Ashok Bhushan, M.R. Shah and Subhash Reddy also issued notice on the plea seeking revival of the SIT probe and posted the matter after 4 weeks for final disposal. Senior advocate Dushyant Dev appeared for the YS Jagan Reddy government and submitted that the High Court order is extraordinary. He said that it stopped the entire investigation into allegations of fraudulent practices and abuse of power. Further, Dev added that the High Court could not have exercised such broad powers as it is also bound by the laws declared by the Supreme Court. Justice Bhushan-led bench issued notice on the appeal as well as on petitions for interim relief. Respondents have been directed to also file counter affidavit and liberty has been granted to file additional documents. Andhra Pradesh government has moved the Supreme Court against High Court order restraining any media reporting as to the FIR registered by the Anti-Corruption Bureau, alleging corruption and illegal land transaction in relation to the shift of the capital to Amravati following the bifurcation of the erstwhile state of Andhra Pradesh in 2014. The Andhra Pradesh High Court, while staying the SIT probe, had noted that rule of law demands continuity and a new government cannot be permitted to overturn the decision of the previous government. The High Court had further held that government in exercise of its executive powers does not have an inherent power of review. However, the plea before the top court contended that investigation in this case could not be termed as a power of review. Bureau Report. The Supreme Court has summoned Maharashtra Assembly Secretary for contempt, intimidating Arnav Goswami. The Secretary has been asked to remain personally present for the next hearing and to explain why contempt of court action should not be initiated against him.
The Supreme Court on Friday summoned Maharashtra Assembly Secretary for allegedly intimidating Republic TV editor Arnav Goswami, which the court observed was done with the object of deterring Goswami from moving the Supreme Court. A bench headed by Chief Justice of India S.A. Bobde took strong exception to a letter written by the Secretary to Goswami on 13th October, in which Goswami was allegedly berated for producing before the Supreme Court the minutes of proceeding sent to him by the Speaker and Privileges Committee of the Maharashtra Legislative Assembly in relation to a breach of privilege motion. CJI S.A. Bobde said that such attempt to prevent citizens from exercising their right under Article 32 would amount to serious interference with the administration of justice. The Secretary has been asked to be personally present and explain why contempt of court action should not be initiated against him for the October 13th letter. The court also observed that the letter was in the teeth of Article 32 and amounted to a threat to prevent Goswami from moving the Supreme Court. The secretary in his letter to Goswami had stated that though the Republic TV editor was informed that the proceedings relating to the breach of privilege motion by Maharashtra Assembly against Goswami were confidential, he had presented the same before Supreme Court. The intention of the officer seems to be to intimidate the petitioner because he moved the Supreme Court and to threaten him with penalty for doing so. The officer would have been well advised that the right to approach this court under Article 32 is itself a fundamental right, the court said. Goswami has approached the court challenging the September 16 privilege motion sent to him by the Maharashtra Assembly for his criticism of the government in action in the Sushant Singh Rajput case. The 60-page privilege notice against Arnab Goswami was sent after motion were moved against him by the Shiv Sena in both Assembly House in Maharashtra. A privilege motion can be moved if an individual or authority violates or disregards any of the privileges, power and immunities of the House concerned or member of the House or committee. What amounts to breach of privilege or contempt is decided by the House, which also decide the punishment. In his response to the notice, Goswami had released a statement on his channel, Republic TV, stating that he would continue to question Uddhav Thackeray and elected representatives and that he has decided to contest the notice. Bureau Report.
And during a hearing on pollution, Center informed the Supreme Court that a panel to monitor stubble burning has begun work. The Supreme Court asked the central government to ensure that there is no smog in Delhi NCR. Senior advocate Vikas Singh, appearing for petitioner, said the pollution had worsened in Delhi, to which court said that let government take steps to curb pollution.
The central government should take steps to ensure that Delhi National Capital Region (NCR) does not grapple with smog in the coming days. The Supreme Court said on Friday, observing that courts have limitations in dealing with such issues. A three-judge bench headed by Chief Justice of India S.A. Bobde asked Solicitor General Tushar Mehta to ensure that the national capital is not impacted by smog and bad air quality, while calling for grading actions offences that contribute to decline in air quality index AQI. Solicitor General Mehta informed the top court that a body known as Commission for Air Quality Management for NCR and Adjoining Areas Commission has been set up by the central government and will start functioning from 6th of November. The centre, in exercise of its power under Air Quality Management in National Capital Region and Adjoining Areas Ordinance 2020, had constituted the commission on Thursday for tackling air pollution and plummeting AQI level in the NCR. Senior advocate Vikas Singh submitted that the condition in Delhi was akin to public health emergency and that some drastic measure need to be taken. However, the CGI stated that the case will be taken up after Diwali vacation and that the court of law has limitations since executive is the body with money and resources. We have certain limitations and we are not abdicating our responsibility. Let centre take steps, the CGI said. Though Singh raised issue with regard to the composition of the commission and how no members from the Health Ministry was part of the commission, the court stated that those issues will be examined after the Diwali vacation. The problem of stubble burning and the consequent air pollution caused in Delhi NCR was highlighted in a petition filed by Aditya Dubey. Among other things, the petitioner had recommended setting up of a monitoring committee and had suggested that retired Supreme Court Judge Justice Madan Lokar should head of the committee. The Supreme Court had agreed to the same and appointed Justice Lokar as one-man committee to monitor and prevent instances of stubble burning in the states of Punjab, Haryana and Uttar Pradesh. This order was passed despite strong resistance from Solicitor General Mehta. Bureau Report.
That's it for Courts Roundup today. Thank you for tuning in. Keep watching APN for more updates from around the nation.
India Legal presents Court This Week.